Good morning, everybody. Good morning. Oh, I know it's early. But this is the time that worked for me, getting started here, reading through Miss Letitia James's brief regarding the New York fraud case. So, good morning. Happy Saturday. Happy Saturday, everybody. Again, I apologize it being so early, but this was just the time that was going to work for me today. So I'm hoping to be able to do this in multiple sections throughout the day today. Just do one piece and then come back and do another piece later on. So I will just be doing these in kind of 45-minute segments in order to read through this whole brief. It's an incredibly well-written brief. So I wanted to get it started this morning. So good morning again. This is the brief that has been filed for Miss Letitia James, the Attorney General for the state of New York. This is her response to Mr. Trump appealing the New York civil fraud case. So her response was due a couple of days ago, and this is what we'll be going through throughout the day today. And then Mr. Trump has a reply brief next week that can be turned in as well. Then we have oral arguments for this appeal set for the last week in September for the Court of Appeals in New York, First Division. Let me make sure I have the correct names in New York. Their names are a little bit different. The lowest court is actually called the Supreme Court. That's our trial court. Then we have the First Division, the Appellate Division. It can actually be the first or the second department. And then on top of that is the Appellate Court is what they call that. So the Court of Appeals. So we are at the first level of appeals here with this brief. So that's what I'll be reading through for just a little bit this morning to get everybody started. And then I hope to come back multiple times throughout the day to continue to finish reading this case up. So let me go ahead and get started here with our which color should be today? We'll do pink today with our brief. So welcome in. I do have comments off. I will do a Q&A after reading through a little bit of this document. So we'll go ahead and get started. Again, I will be doing multiple lives going over different pieces of this as I go through. It is a very lengthy brief, so I will need some time to make it through. So here we go, everybody. This is again Miss Letitia James's response brief to the New York fraud appeal filed by Mr. Trump. This was filed 8/21 at 10:44 p.m. I have done a post already on the table of contents if you'd like to review that. So I will just go ahead and dive in. Here we go. We have Miss Letitia James's names there. Then the first thing we have is the table of contents. Once I start reading, I will add my sticky note back. But we've got the table of authorities, preliminary question, question presented, statement of the case, statutory background here. The section of the code that they're using in New York is a unique law, which has to do specifically with fraud and perpetual fraud in New York. Next, we have the factual background. We've got subs 1, 2, 3, and 4, where defendants have used and tried different fraudulent ways of continuing their business in New York. So she set those out here with a couple of specific examples with the Deutsche Bank down here as well as other lenders. So next then she will set out the procedural background specifically regarding 6312. Now this is what's so unique is this law here set out in New York. Which allows for the AG to bring a lawsuit just like this one in order to kind of stop the business fraud that can go on in New York. So then she's got her rest of her points here. Next up will be her argument then. She has 3 primary points. The first point is the Supreme Court, so the trial court, properly found defendants liable for violations of Executive Law Section 6312. And then she sets out her argument further there. And then continuing on. And point 2, the Supreme Court properly granted equitable relief, which as we know is around that $450 million range. which will most likely be up in the $500 million range by the time this gets through all of the appeals. So she set that out in her second point. And then her third point, the Supreme Court, here the trial court, appropriately sanctioned defendants as attorneys. So their attorneys were sanctioned for frivolous motion filing. And then she wraps it up with a conclusion. Next up, we've got the table of authorities where she sets out all of her cases that she will be using and which pages they are cited for the first time, set here. And then again, I'm just kind of going through this very beginning piece so I can start getting in and actually reading the brief. I will be doing multiple lives today. I'll need to break them up into multiple sections because this brief is so large. So here we go, continuing on through the cases here. And next she sets out the constitutions used. Of course, we have the New York Constitution and the U.S. Constitution. We have multiple pieces here along with the laws in New York set out as well. So we've got multiple criminal code sections and the rules are also set here. Now, anywhere you see penal law, of course, criminal law, it means that there's a penalty involved. So that's how we address our criminal law sections here. We have the rule for trial courts, what they're allowed to do, and then she has included miscellaneous authorities here. So setting out some different things such as the restatements and so on. So that takes us then, everyone, to the very first page of the brief, which we will get started on here. I will read just a little bit into the brief and then I will do a Q&A. And again, I will need to break this into multiple lives today. So welcome in. Thanks for joining me. I appreciate you being so flexible with my schedule. So preliminary statement. For years, the Trump Organization and its top executives engaged in a fraudulent and illegal scheme to misleadingly inflate the net worth of defendant Donald J. Trump, as reflected in his personal financial statements, by as much as $2.2 billion each a year. Each year, defendants used a new misleading statement in conducting business with lenders, insurers, or others, while falsely representing that the statement was accurate. Through their misconduct, defendants derive significant economic benefits they otherwise could not have obtained, including over $360 million in illegal profits, which is why we have got that disgorgement issue coming up. Following an investigation, the New York State Office of the Attorney General, or the OAG, brought this civil enforcement action under Executive Law 6312 at summary judgment. Supreme Court New York County, Judge Engeron, concluded based on the extensive and undisputed documentary evidence that defendants had engaged in fraud in violation of Section 6312. Following an 11-week bench trial, Supreme Court issued factual and credibility findings and concluded that defendants had also engaged in criminal illegal conduct in violation of Section 6312. Exercising its equitable discretion, the court ordered as remedies disgorgement of defendants' ill-gotten gains and injunctive relief. This court should affirm Supreme Court's liability determinations are supported by overwhelming evidence that in each statement, thank you everyone for the gifts, defendants used a variety of deceptive strategies to vastly misrepresent the values of Mr. Trump's assets. For example, defendants valued Mr. Trump's apartment as if its square footage was triple its actual size, valued rent-regulated apartments as if they were unregulated, valued Mar-a-Lago as if deed restrictions that Mr. Trump signed did not exist, and valued golf properties by secretly including premiums that defendants represented were not included. On appeal, defendants tellingly ignore almost all their deceptions. Instead, their primary argument that the AG failed to prove the defendants' counterparties relied on the misrepresentations to their financial detriment. But it is well established that neither reliance nor victims' losses, which are elements of common law fraud, is required for Section 6312. Fraud or illegality claims, whereas here the AG seeks disgorgement and injunctive relief, rather than damages or restitution. So this is really important, everyone. She's saying here, common law fraud requires some kind of reliance by victims. And what she's saying is this section of the New York law does not. We do not need to have a victim's reliance here. What we need to have is illegally gotten gains. So that's the difference between any kind of penalties and disgorgement. Indeed, one of Section 6312's core remedial purposes is to protect the honesty and integrity of commercial marketplace in New York by stopping fraudulent and illegal practices before they cause financial losses to market participants or broader harms to the public. In any event, as Supreme Court correctly found, again, this is the trial court in New York, defendants' counterparties did rely on the misrepresentations and omissions to their detriment, and Supreme Court properly determined that defendants, who were each deeply involved in the misconduct, knew the statements were misleading and intended to defraud. Indeed, as the court found, defendants' testimony to the contrary was contravened by the documentary record and not credible. Defendants make numerous additional arguments against liability, none of which has merit. For instance, Supreme Court correctly concluded, consistent with this court's earlier decision, that defendants violated Section 6312 each time they used a new fraudulent statement in business. Under traditional accrual principles, the AOG's claims are timely as to each such violation after July of 2014, the start of the limitations period. Supreme Court also acted well within its equitable discretion in awarding relief based on defendants' numerous and blatant violations of Section 6312. Supreme Court did not unwind any of the business deals. Between defendants and their counterparties, the court instead properly ordered defendants to disgorge only the ill-gotten profits of their wrongdoing, a well-established equitable remedy that accords with both the excessive fines and due process clauses of the state and federal constitutions. Supreme Court also properly ordered injunctive relief after considering and weighing inter alia the flagrancy of the defendants' misconduct, their high degree of scienter, which is intent, their prior history of wrongdoing, and their refusal to accept any responsibility for their misconduct. Finally, Supreme Court also properly exercised its discretion in imposing monetary sanctions on defendants' attorneys for raising frivolous arguments at summary judgment. So that is our introduction here by the Attorney General in New York. Here's our questions presented. Number 1, whether the Supreme Court, so the trial court, everyone in New York, correctly concluded at summary judgment that defendants engaged in repeated and persistent fraud in violation of Section 6312. Number 2, whether Supreme Court properly concluded after an 11-week bench trial that defendants engaged in repeated and persistent illegal conduct in violation of Section 6312. 3, for questions presented, whether Supreme Court appropriately exercised its broad discretion in ordering defendants to disgorge their ill-gotten profits and issuing injunctive relief, and 4, whether Supreme Court appropriately imposed monetary sanctions on defendants' attorneys for raising frivolous arguments. So those are our 4 questions presented, which is what you have to have in an appellate brief. Statement of the case, Sub A, statutory background. The legislature enacted Executive Law 6312 in 1956 to protect the honesty and integrity of commercial marketplaces in New York by stopping fraudulent and illegal business conduct. To accomplish this public purpose, 6312 broadly authorizes the Attorney General to bring civil enforcement proceedings whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transaction of business. Executive Law citation here. Section 6312 applies to fraudulent or illegal conduct in business, regardless of whether it targets consumers, small businesses, large, corporations, or other individual entities. As the legislature broadly provided, the terms fraud and fraudulent in the statute shall include any device, scheme, or artifice to defraud, and any deception, misrepresentation, concealment, suppression, false pretense, false promise, or unconscionable contractual provisions. The term repeated includes repetition of any separate and distinct fraudulent or illegal act or misconduct affecting more than one person. The term persistent includes the continuance or carrying on of any fraudulent or illegal act or conduct. As relevant here, an act is illegal under Section 6312 if it violates another state law, including the penal law or criminal law. The broad sweep of Section 6312 was patterned on the Martin Act, GBL Section 352, enacted in 1921 to combat fraud in the securities market. This section of the law, like the Martin Act, is a remedial statute that reaches well beyond the common law concept of fraud. She's making that distinction, everyone, between this section of the code and what we refer to as just regular fraud in the criminal system. Liability under 6312 does not require that market participants relied on the fraud or illegality or suffered losses resulting from it, which has been one of Mr. Trump's number one points has been no one was harmed. And she's saying no one has to be harmed under 6312. The statute's broad sweep ensures that the Attorney General can bring enforcement actions to protect market participants and stop misconduct before it causes losses. Factual background, sub B. The background that follows is taken from the undisputed documentary record developed at summary judgment and the evidentiary record subsequently developed during an 11-week bench trial during which 40 witnesses testified. As a side note, undisputed documentary record is saying that none of the evidence was actually contested by Mr. Trump. So all of the evidence that the state put on in its motion for summary judgment, none of it was contested for that summary judgment. So one of the ways that you fight against another person in trial is that you need to discredit or say that their evidence is wrong. That did not occur here. Documentary evidence cited herein was both submitted at summary judgment and admitted at trial, unless otherwise noted. Mr. Trump is the beneficial owner of entities that do business as the Trump Organization. The Trump Organization includes the entity defendants and employed the individual defendants as executives, including Donald Trump Jr. and Eric Trump, Alan Weisselberg, the former chief financial officer, and Jeffrey McConney, the former controller. In conducting business, defendants annually prepared a personal financial statement for Mr. Trump, which they refer to as the statement. Each statement purported to fairly and accurately represent Mr. Trump's net worth as of the date the statement, based principally on the asserted estimated current values of Mr. Trump's assets minus outstanding liabilities. But instead of providing an accurate representation of Mr. Trump's finances, defendants used varying misrepresentations and omissions to vastly misrepresent the values of Mr. Trump's assets. As a result, defendants inflated Mr. Trump's personal net worth by as much as $2.2 billion a year, and that's a lot, on more than 24 separate occasions from at least 2014 until 2021. Defendants used one or more of the different false and misleading statements in their business dealings with lenders, insurers, or others, while representing that the statements were true and accurate to re-up significant financial benefits. And then we have footnote 2 here. This brief refers to the statements by year, indicating the year ending in June for which the statement values Mr. Trump's assets. In some cases, the statement was completed and submitted the following year. So now she is setting out, again, all of this evidence to support what she's saying. So all of these different pieces. Number 1, defendants used various deceptive strategies to inflate the values of Mr. Trump's assets as reflected in his financial statements. The deceptive strategies that defendants used to misleadingly inflate the asset values in each statement were numerous and differed from year to year. There are some demonstrative slides summarizing that. And I have done a post where they put together a chart actually going through all of the different deceptive strategies. And I believe that's the chart she's referring to here. As trial testimony showed, defendants used these strategies to reverse engineer the value of Mr. Trump's assets to achieve a net worth that Mr. Trump wanted. For example, after reviewing the draft statement, Mr. Trump might say, "I'm actually not worth $4.5 billion. I'm really worth more, like $6." Again, and we're citing different pieces of evidence here. The draft statement would then be revised to inflate asset valuations to reach Mr. Trump's preferred net worth for the final statement. Defendants' deceptive strategies fall into 4 categories. So she's going to break down the different strategies here for us. False or inaccurate information. Defendants used false or inaccurate information to calculate many asset valuations. Each statement from at least 2014 to 2016 valued Mr. Trump's triplex apartment in Trump Tower as if it were 30,000 square feet, but the apartment was only 10,996 square feet. Valuing the apartment as if it were nearly 3 times larger than its actual size overstated its value by up to $200 million. Defendants knew that these statements misrepresented the size and value of the apartment. Mr. Trump resided in the apartment and had signed a document in the Trump Organization's file stating the apartment was only 10,966 square feet. Again, she's citing the evidence here. Moreover, this misrepresentation continued after the Forbes magazine inquired in early of March of 2017 whether Mr. Trump had been misrepresenting the apartment size. Eric Trump, Donald Trump Jr., and Weisselberg were on emails discussing Forbes' inquiry. Yet, after this inquiry, Weisselberg ordered another employee to leave it alone and did not inform outside accountants that the value was incorrect before the final 2016 statement was compiled a few days later. When defendants used the correct apartment size for the 2017 statement, trial evidence showed that they used different strategies to inflate the value of the apartment and other assets to offset the reduction. Each statement from at least 2014 to 2021 also falsely and misleadingly inflated the amount that Mr. Trump personally held in cash. Specifically, defendants included cash held by Vornado Partnership, or the Vornado cash, over which Mr. Trump had no control, and the category for his personal cash assets. And then here's the evidence. Defendants included the Vornado cash despite Weisselberg and McConney having been told by an outside accountant that the cash category could not include assets that Mr. Trump did not control. When asked if he controlled the cash, Mr. Trump admitted in the true sense, no. And then she's citing his deposition here. At trial, one of the defendants' own experts labeled the inclusion of the Vornado cash and Mr. Trump's personal cash asset category as a red flag and very glaring issue that contravenes generally accepted accounting principles, or GAAP. Similarly, Mark Hawthorne, a Trump Organization executive with CPA training, conceded the defendants had overstated Mr. Trump's cash by including the Vornado cash. This misrepresentations inflate the cash reported in statements by $16 to $93 million, depending on the year. Omissions of legal restrictions. So this is the next category of deception, everyone. Defendants also valued Mr. Trump's assets in regard to known legal restrictions that diminished their value. For example, each statement from at least 2014 to 2018 misleadingly valued certain properties as if many buildings could be developed on them, when in reality, far fewer buildings could be developed. The statements valued a golf property in Scotland, Aberdeen, as if over 2,500 private residences could be constructed and sold, when defendants had obtained approval from the Scottish government to build only 1,486 accommodations on the property. including only 500 private residences. This misrepresentation inflated the property's value between $59 and $283 million. At trial, Mr. Trump stated that valuing this golf property was sort of like a painting where you could do what you want to do. Similarly, evidence at trial showed that the statements misleadingly valued underdeveloped land in Briarcliff, New York, as if 71 units could be built when the defendants have the right to build only 31 units, under which Eric Trump knew. Again, each one of these numbers is a citation to the evidence. Eric Trump also knew that a professional appraiser, David McCardle, had repeatedly valued the undeveloped land at Briarcliff at approximately $45 million, which assumed that 71 units could be built for purposes of a potential conservation easement. He nonetheless instructed McConney to list the land's value at approximately double that amount, $101 million, on the 2015, 2016, 2017, and 2018 statements. At trial, McCardle testified that Eric Trump had certain ideas about value and that McCardle and others had recognized during the easement appraisal process that anything beyond $45 million would have put some people at risk and would not have been credible. Each statement from at least 2014 to 2021 also valued Mar-a-Lago based on the false premise that it could be sold as an unrestricted private residence. But to pay significantly lower taxes on Mar-a-Lago, Mr. Trump had earlier signed a deed agreeing to forever extinguish his right to develop or use Mar-a-Lago for any purpose other than club use, and granting a preservation easement in perpetuity to the National Trust for Historic Preservation that prohibited Mar-a-Lago's use as anything other than a social club without the National Trust's written approval, valuing Mar-a-Lago as an unrestricted private residence rather than as a social club inflated its value on each statement by approximately $300 to $700 million, depending on the year. From at least 2014 until 2021, each statement also valued unsold rent-stabilized apartments in Trump Park Avenue on the false premise that they could be sold without rent stabilization restrictions. Despite knowing that the apartments were rent-stabilized, McConney and Wesselberg intentionally valued the unsold apartments using an asking price that assumed that the apartments were unregulated and hid this information from the Trump Organization's outside accountant. One of the defendants' own experts recognized that failing to disclose that rent-stabilized apartments were valued without legal restrictions is a pretty significant omission. This omission inflated the apartment's value by $10 to $90 million. Number 3, methods that contradicted specific representations. Defendants value certain assets categories in ways that contravene specific representations that they had made in the statements. Each statement from at least 2014 until 2020 falsely represented that the goodwill attached to the Trump name has significant financial value and has not been reflected in the preparation of this financial statement. In fact, defendants inflated the values of golf clubs' properties by either 15% or 30% based on their value purportedly associated with Mr. Trump's name. Statements from at least 2014 to 2018 and 2020 to 2021 further misrepresented the value of the transactions in which Mr. Trump licensed his name for use on third-party real estate projects. Each statement represented that these valuations included only licensing arrangements that have evolved to a point where signed arrangements with the other parties exist, and fees and other compensation which he will earn are reasonably quantifiable. In fact, defendants secretly included unsigned deals in intra-company agreements between Trump Organization affiliates. And then she is citing the documents showing that here. Including a handwritten note of inclusion of forecasted deals that have not yet been signed. This misrepresentation inflated the values of these projects by approximately $100 to $200 million. I'm sorry, $100 to $200 million. Number 4, disregard of accounting methods and appraisals. Last, the statements valued Mr. Trump's assets in ways that ignored professional appraisals or significantly departed from accepted methods without disclosing those appraisals or departures. For example, to inflate the value of 40 Wall Street, evidence at trial showed the defendants, among other things, cherry-picked a figure from a professional appraiser's widely disseminated generic marketing report about the properties in the area while ignoring the different figure, which produced a much lower valuation that the same professional had used in preparing a bank appraisal of 40 Wall Street itself. Defendants then hid their deception from outside accountants by forwarding an excerpt of an appraisal that included their cherry-picked figure while omitting other pages showing that the appraiser had used a different figure. And then again, she's citing to the documents showing that. Defendants also valued properties without disclosing various independent appraisals that valued the properties at hundreds of millions of dollars less, including the 40 Wall Street, Vornado Partnership properties, Trump Park Avenue here. For example, in the 2014 statement, defendants valued the Seven Springs property in Bedford, New York at $291 million, when a professional appraiser evaluating a potential conservation easement had told Eric Trump that the property was worth at most $64 million. When defendants corrected this overvaluation for the 2015 statement, they hid the change by placing Seven Springs in the other assets category on the statement, where it was not itemized, while also increasing the purported values of Mr. Trump's triplex apartment in 40 Wall Street. And if you want to see those documents, you can look them up here. Trial evidence also showed that many valuations did not reflect an asset's estimated current value, the amount at which an asset could currently be exchanged between a well-informed and willing buyer and seller, even though the statements expressly provided that assets are stated at their estimated current values. For example, for certain undeveloped properties, defendants valued unbuilt residences as if they had already been built and sold, without applying a discount factor to these assumptions about future profits. And this includes the golf club membership fees, fees on real estate licensing transactions that have not yet occurred, and Seven Springs again. As one of the defendants' experts acknowledged, failure to discount future profits would be a red flag that would raise a glaring question as to the statements' accuracy. And with that, everyone, I will go ahead and turn on Q&A for today, for this morning. I will be breaking this into multiple parts and reading through. But for the first part, I think this is an okay stopping point. So let me go ahead and turn on the comments here. There we go. Good morning, everybody. Good morning, good morning. Let me go ahead and mark where we stopped here so I can make sure to come back to the exact spot when I come back again later on. So, welcome in, everybody. As an accounting student, oh goodness, yes. Oh, I bet. And I was not an accounting student, but it seems like a few basics here are being are being looked over. Good morning. Yes, hello, Kaya. Good morning. Good morning, everybody. Very well written and accurate. I think so. I'm on very early, Dusty. I'm on very early. I've been missing doing my live so much, and woke up this morning and was like, oh, I gotta get on. Gotta get on as soon as I could. So I'll be breaking this brief up into multiple lives throughout the day, everyone. Hopefully being able to come on every couple of hours. I've got to rest my voice and then I'll be able to come back on. But I'm hoping to actually make it through this brief. So make sure to turn your notifications on throughout the day. I'm not sure exactly when I will be on and off. It will depend. But good morning. Hello. Good afternoon, Deborah. Hello. Yes, I wasn't planning on black today, but this is just what happened. So, oh, I've been missing the lives. I really have been, everyone. I've been just not feeling the greatest, but I woke up this morning and I was like, I've just got to get on as soon as I could. 3 p.m. All right. Well, it's nice then. Ready for an afternoon nap, perhaps. It's been raining a lot here, so I've been thinking about you, Deborah. I'm like, oh, I should have a cup of tea. Celebrate. Have you done an update on the documents case? I've not done an official update yet, but we really don't have much of an update on the documents case. We have a brief due by the government next week in the Florida documents case. So next week we should actually hear something from the Florida documents case, and it should be pretty significant. So Jack Smith's team needs to file a statement supporting their notice of appeal. So that is coming in next week. So just in a few days. So we should have some pretty good updated details on Florida for that. Good morning. Yes. Good morning. Good morning, everybody. Good morning. Good to see you all. On the January 6th case, is it true that Jack is opting for no mini trial? So I've not heard that. Also, they are going to do an updated status of the case. Both sides will have that in next week. That's due next week, and then they're going to have a conference the following week. But at this point, based off of what Judge Chutkin is saying, she's saying, let's look at this. Let's talk about it. And according to any of the filings, any of the official language, I've not seen anything where Jack has said, no, we can't do this. And I'm not sure how she's going to be able to make the decisions she needs to make without holding some hearings. And pretrial hearings happen all the time. They happen all the time. What doesn't happen all the time is this determination of immunity. That's what's unusual. But we do have pretrial hearings all the time. So we'll see what happens. That case drives me crazy. Oh, I know. Well, and also you have to keep in mind, we do have a civil case where they're deciding the same issues in the civil case, in the Blessing Game case, and that's ongoing as well. It's going at the same time. So they're kind of parallel to each other. We're kind of keeping an eye on both of those. This is separate from Stormy. Right. So this is the civil fraud case that we're looking at here. This is the appeal from that holding, from that ruling, which was in two parts, a summary judgment as well as a bench trial. So that's what this is, but the Stormy Daniels election interference, hush money case, there's lots of names for it. The 34, what I refer to it as, the 34 felony convictions. That case with Stormy Daniels, that's a different one, and that's set for sentencing on the 18th. The immunity question, I guess, is set for the 16th on that. IRS kicks in, Trump. Oh my gosh, the IRS is coming down the road. Yep, coming down the road. Thank you. You're welcome. You're absolutely welcome. Yes, you're welcome. There really is a lot going on, actually, everyone. We're going to have a busy next few weeks. We've got even stuff in Georgia. I mean, we've got Mark Meadows has a writ of certiorari on file, and so we're going to see a response to that from DA Willis coming up. So was he convicted on this case? So this case is a civil case, so there's no convictions. There is an account. Well, we've got a finding where he's been held liable for fraud. So he has violated the civil code section, and there has been a finding of that. So that's what this case is about. So he is found liable, along with him and his et al., which are multiple people and organizations, have violated 6312 of the New York Code, and he's appealing that. Yes. And then he has been, there have been damages and disgorgement that have been set out as well. I was going to say, it's so hard keeping up. Oh, I know. It's very hard to keep up. Yeah, it's hard to keep up. I know. I know. Well, and this isn't the only civil case either. We have E. Jean Carroll cases 1 and 2. We also have we've got those those two cases, plus we've got some other civil cases going on. I always am keeping an eye on the Giuliani defamation case. We've got some defamation cases going on as well. So, we've got a lot of cases going on. Liability was found. Yes, you got it. Yep, you got it. Yep. Good morning. Good morning. Yes. Well, welcome in, everybody. It's going to be a busy couple of weeks ahead of us, everyone. We've got decisions and arguments and filings that are going to be coming out. Probably the big one that everyone will be looking forward to will be later on at the end of the week. We will have the government. Jack Smith will have a filing for the documents case, the Florida case, on file by the end of the week. Next week. Yes, good morning. Good morning. Good morning. This isn't the only case for him. Oh, I know. There's a lot. Yes, I will try to keep everybody straight. We also have, the Cohen case, which has a writ of certiorari. We have the Grant case, which has oral arguments coming in. So, there's just a ton of cases, everybody. There's a ton. I'm happy to come in and try to just keep it straight, because I don't think everybody needs to have the full, dog and pony show. They just need to have, what's going on. So I'm glad to just kind of give the updates. So this morning, I had been on earlier to read the first part of this brief, and I will be throughout the rest of today, everyone, coming back on and doing short readings and then quick Q&As afterwards. I'm trying to make it through this brief, but I have got to do small pieces of it. So make sure you've got your notifications on for today, everyone, because I will be kind of on and off throughout the day today. Oh, as annoying as Kamala is, that's sweet of you to say, actually. I find that to be a compliment. I think I've been doing lives now for a really long time, and I've had so many people tell me that my laugh is like Kamala's, and I never noticed it. But now that I've heard her laughing, I'm just like, oh, that's sweet. I appreciate that. What's the Cohen case? Yeah, so Cohen has sued the Department of Justice, and there's a lot of weird stuff going on regarding, solitary confinement and exactly what happened with him when he was in prison. So he has lost that case, but is appealing it. So we've got another one that's set. He's filed his petition on July 10th for writ of certiorari. So it's actually a Cohen versus U.S., Trump, Barr, and etc. So all forms is a good thing. Well, I think it's all right. I think it's all right to have some chuckles. Nothing wrong with that. Nothing wrong with that, everybody, especially right now. Oh, my goodness gracious. So, very infectious. Oh, that's so sweet of you. That's so sweet of you to say. So I will definitely, so as of right now, we've just made it through, again, just the beginning portion of this brief. I put the table of contents on already as a full post, everybody, if you're interested in that. But I've read through that, and then just the beginning here to get us started. The manpower to take on. I wonder too, Denton, I'm wondering if they had to kind of outsource it. I have this feeling that there's a whole division in the IRS that's just like the Trump and Trump people division. That's what I have in my mind. Learned so much about the court system. Oh, good. Oh, I'm so glad it's been helpful. Oh, I'm glad. I'm very, very glad. I love to hear it. I have this brief I'll continue on through, everyone, but I've got lots of other things in store for us for the lives coming up. Unfortunately, I've not been able to come on recently. I've not been well, but hoping to turn the corner here. But I've got some very interesting cases. We've got a civil lawsuit right now for a terrible assault type situation. We've got the Trump v. Clinton case that's being appealed. So we've got a lot of stuff going on. We also have the Stephanopoulos case, which is going on, which goes hand in hand with the other assault case. So lots and lots going on. I'm hoping to be able to start live streaming again over on my Tube of You very, very soon as well. So hoping that will happen. Excellent. Thank you, Murray. I appreciate that. So, oh yes, I do appreciate that. But I do have a timer on today, everyone. So I will need to go ahead and sign off for this first live for today. Make sure you turn your notifications on. I will be back again